Hi, I'm Weston Montrose, and I'm certified by the State Bar of Arizona as a specialist in workers' compensation. I'm a founding member in the law firm of Arizona Injury Law Group. Please visit our website at www.arizonainjury.com. I'm going to be discussing the independent medical examination, or the IME. In a workers' compensation case, if the insurance company has a dispute or a doubt about your medical condition, then they can require that you report for an independent medical examination, also called the IME, and it's with the doctor that they choose. So for example, if they have a question about whether you have a medical condition associated with your reported work activity, they can schedule an IME. If they're wondering whether you require additional treatment for an accepted claim, if they're wondering whether you require supportive care that's going to help you cope with your condition, like diagnostic testing, medicines, therapy, or some other medical attention, even if it's not necessarily going to make your condition better, if it's going to allow your doctor to monitor your condition or help you to function in light of your permanent problem, they can get an IME. If they want to know if you have a permanent impairment, if your condition is stationary, they have a question whether the American Medical Association guidelines have a permanent impairment rating. Do you have work restrictions, or can you return to 100% of your pre-injury job duties? Sometimes people want to know if they can refuse to attend the independent medical exam. The answer is yes. You can refuse to attend, but there are some severe negative consequences for refusing to attend an IME. Specifically, the insurance company can suspend your benefits. That means they can refuse to pay you any more lost wage benefits, and they can refuse to cover your medical treatment. If you unreasonably refuse to attend an IME, they can also issue a notice claiming that they want to charge you for the cost of that independent medical exam and deduct it from any benefits they owe you. There are limited circumstances to avoid those negative consequences for refusing to attend an IME, and that requires that you file a motion for a protective order. These are very limited circumstances and have limited time frames to file with a judge to request a protective order. Who pays for the IME? The insurance company has to pay for the IME. If it's on a location outside of where you live, you can ask for the insurance company to pay for your travel costs to attend the IME. The IME doctor is not your doctor. In fact, there's no doctor-patient relationship established at the examination. Technically, the IME doctor is not the employee of the insurance company either, and that's why they are called independent. People want to know if they can record the independent medical exam. Yes, you can. Arizona law allows you to make an audio recording of the IME. As a common courtesy, you need to inform the IME doctor in advance that you intend to audio record the exam. But there is no legal authority that allows you to bring a video camera to the IME. Can you bring someone to the exam? Yes. You can bring your own doctor with you to the exam, but you need to make your own arrangements with your doctor, and you need to compensate your doctor for attending. As a practical matter, this is extremely rare because of the expense involved. In fact, I can't recall this ever happening in any of my cases. You should also provide advance notice if you intend to bring your own physician to the exam. You don't have the right to bring anyone else into the exam, such as a friend, a spouse, or a family member. However, if the IME physician is willing to allow somebody to attend, that's the IME doctor's prerogative. The IME doctor is selected by your insurance company, or sometimes by a third-party agency that the insurance company has hired to organize the IME. Unfortunately, this can create the incentive for the doctor to minimize the scope of your injury with the result of lowering your benefits, but you have no control over the selection of the IME doctor. A purpose letter is something that the insurance company provides to the IME doctor in advance, explaining the history of your injury, summarizing your medical care, and asking certain questions about your case. These are the questions used to frame the issues that the doctor will answer. For example, the doctor can be asked his or her opinion about what's your current diagnosis, whether your current symptoms are related to your work accident, whether surgery or some other treatment recommended by your doctor is necessary. You can ask to review the purpose letter sent to the IME doctor from the insurance company. That way you can correct factual mistakes and see if the questions were asked in an unfairly suggestive way. Before the examination occurs, the insurance company will gather your medical records and any other documents relevant to your injury, such as the injury report, statements from coworkers, statements you've given, and they'll send them to the IME doctor. The IME doctor normally reviews these documents either before or after your exam in combination with the purpose letter from the insurance company. During the examination, the doctor will likely start out by asking you questions about how your injury happened. Sometimes this is in paper form. They'll ask what symptoms you're experiencing, whether you have a history of prior medical issues, what treatment you've received for your injury so far. You should be sure to tell the IME doctor about any areas of your body that are still symptomatic and about any activities that are being affected by your injury. Be thorough when you describe your problems, but do not exaggerate. If the IME doctor thinks you're overstating your problems, he or she will not become more sympathetic. Rather, they will probably hold this against you and label you as a symptom exaggerator. During the IME, do not expect a normal physician-patient relationship. This means that anything you tell the doctor is not privileged or protected in any way. Your statements to the doctor can be used against you at a workers' compensation hearing if your case gets that far. This is also true of observations the doctor makes. For example, if the doctor sees you walking normally from your car to the office, but then sees you grimacing with pain and limping around on one leg in the office, he's going to make a note of that. This is the kind of inconsistency that will show up in the doctor's report, and the judge could take this into account when assessing your credibility. You should not expect the IME doctor to answer any questions you may have. They will likely tell you that they will put their opinions in a report and that you can request a copy later. The IME doctor usually conducts some form of physical examination focusing on the body part in question. This can be a visual inspection, range of motion tests, hands-on tests, or instrument tests. Sometimes the examiner will request additional diagnostic testing later, such as X-rays, MRIs, or EMGs. The examiner could even recommend additional exams by another doctor with a different medical specialty. The IME doctor will write a report addressing whatever questions the insurance company asks them to consider. The insurance company will rely on the IME doctor's opinions to make a determination of whether to authorize treatment, whether to pay you wage loss benefits, whether to close your claim, whether to deny your claim, or make whatever other decision is on the table. If you're scheduled for hearing before a judge at the Industrial Commission, the insurance company can submit that report to the judge and it can be used as evidence at your hearing. Once your physical examination is done, the IME doctor will write a report and send it to the insurance company. They're supposed to send you a copy, but this often doesn't happen unless you make a written demand to get a copy of the report. You should request a copy of this report and read it carefully so you can point out any factual mistakes in your treatment or the medical history. The IME will likely have a major impact on your case. IME reports will be given expert weight by judges at the Industrial Commission. Because they aren't involved in your treatment, they're sometimes seen as more objective, even though that's not the case. For these reasons, it's a challenge to discredit IME doctors' expert opinions. There are situations where it will be more effective to challenge the IME report than others. For example, If the IME doctor's opinion is based on incorrect information about your medical history, or there's some other factual mistake, that will make the conclusion less influential. Even more important is whether your doctor disagrees with the IME. This means it's really important to make sure your doctor has received a copy of the IME report. If your doctor is unwilling to review the IME, express an opinion about the IME conclusions, or testify at the hearing, then you need to consider finding another doctor who's willing to cooperate. The bottom line is that a judge will have no choice but to accept the IME conclusions if you can't or don't produce an alternative opinion from a qualified medical professional. The Industrial Commission's hearing process is not easy. If you want to dispute the IME report conclusions, and the IME is being used against you to limit or cut off your benefits, you should consult with a workers' compensation attorney right away. An attorney can help protect your interests by filing objections, scheduling a deposition to question the doctor, or even requesting another examination.